How's it going out there, Funk fans? I'm back, and I'm letting everybody know I'm back up. My phone decided it wanted to do an update in the middle of this cast. I'm gonna have to invite everybody back in again. Oh man, I don't feel like doing it, but somebody's unfortunately got to do it. And if you have friends, family, associates, anybody that would like some good information, we were breaking down some IRS information, how people are statutorily, and this is how a lot of people get mixed up with the foundation of law, is that statutorily there is a principle for equitable reasons to profit sharing, as far as profit sharing is concerned, and corporatism and integrating finance, is that by making yourself a statutory employee, you fall under the laws because there's a contract stipulating that there's a contract between you or a third party act on behalf of you, a fiduciary, a supplemental provider, a competent institution, or something of that nature that you just simply haven't been privy to be realized or to realize exists. And I'm here to make this. Yes, we're back. Yes, I'm in. Thank you guys. Repost if you don't mind. I appreciate that. Just want to make sure that there was some clarity before anybody decided that I abandoned you guys. I didn't. I love you, and you, and myself. Yes, I love myself. That right there comes as I'm a strategical commodity to one's well-being. If I don't, well, I might as well just go ahead and give my life to something else, some higher institution of thought, and then be consumed by it, and then complain when I'm 80 years old, asking why did I donate all my time to some institution that didn't give it back to me. Well, it's relatively simple. You're not in the contract of receiving benefits. Poor, rich, middleman, negotiator, whatever. Bottom line is that you are unimportant to a stable entity that is there to make money, not to be your friend, not to be your long lost homeboy or associate or some of that nature. No. So anybody that wants to come in, want to talk, I was talking to what's his brother's name again? It's Jeremy Boris. I'm going to invite someone else while I'm on here. Might as well. Invite. Water's warm. It's a beautiful thing in here. You like to talk, discuss. I'm going to mull over the tax code again, kind of get that cleared up. And basically, okay, in general, statutory employees. Hello. Statutory employees, there he is right there. So I'm going to bring him back in real quick. All right. Mr. Boris, beaming you up. Statutory employees, all right, there he is. So statutory employees in general, from those four principles out of the Social Security and Medicare taxes from the first video we had up, kind of goes down to the section below, which is three categories that have to fill Social Security and the Medicaid taxes to act as withholding, to be a withholding agent subscribed by the institution. So it says here, withholds Social Security and Medicaid taxes from wages of statutory employees. If all three of the following conditions apply: the service contract states or implies that that substantially, I'm sorry, I can't even pronounce this word for some odd reason. All the services are to be performed personally by them. In other words, an individual invitation. They do not have a substantial investment in the equipment or property used to perform the services other than an investment in transportation facilities, and the services are performed on a continuing basis for the same payer. Again, I'll repost a link so everyone can go ahead and read it. So again,
Okay.
you're not looking at it like I'm saying it or solidifying it, but I'm not giving it any substance so that you can actually get the general premise for it. So okay, so for the most part, if you're a statutory employee, that means if you are in contract with an institution that withholds your money for the purpose of raising revenue for the state and the federal government, you are a statutory employee by acting as a state and federal agent, raising money on behalf of the United States and the state in which you are part and partially involved in. Matter of fact, Jeremy, do you mind reposting this again?
Yes. Well,
Appreciate that.
yeah, it don't have the share option on it at the moment.
It should. Maybe, well, okay. You might be on your phone. You might be, I think. No?
Right. Yeah, it's not letting me to repost this one. It let me do the other one, but not this one.
All right. Here's what I'll do.
Now, I've gotten away from just paying taxes and everything, but I'm still paying Social Security and
So you haven't gotten away from it. Check your messenger, by the way. Yeah, check your messenger.
okay.
No one's getting away from any taxes unless they have a conclusive contract, which it almost narrowly escapes the actual verbiage you need, which it says here that they do not have a substantial investment in the equipment or property used to perform the services. So in essence, if you own the property that's being used for the service, that's 100% deduction. That means you're not paying taxes on it. Okay, so can you take the link and repost it possibly? Thumbs up doesn't work
Yeah.
for me. Yeah, I appreciate that. Because basically, being a statutory employee means that you are employed to raise money for the United States and the state in which you reside in. To pay Social Security, you're raising funds for the United States in the state you reside in. Simple. Now, the thing is that you never signed a law. So how does that apply to you? Well, it's very simple. As soon as you enter into a contract with a third party, the third party is statutorily required to file taxes because they've entered into those contracts on behalf of itself. So by default, it makes you pay taxes.
Right.
And that's where it goes. Now, a lot of people are taking a lot of my information, go after HR and get your contract, blah, blah, blah. I've been talking about this. The problem is that majority of them don't know how to use it as collateral, which is exactly why these statutory employees can argue all they want about their contract. Well, I work for this company, but I'm not liable. It doesn't say it in there. Well, because the company already states it with the United States and the state because it's subcontracted to do so.
Right.
The entity was created for raising revenue. It wasn't made to do business and not give the government a dime because they made the contract solidified in the company itself, not in its bylaws, but in its conception of incorporating. Let's look at an actual law here that should stimulate any governing mind and has any idea what I'm talking about. So here, we're gonna look up.
Well, I know the company. I've tried to. Well, I haven't tried. I've actually started correcting my standing and status and everything.
Well, here's again. You didn't sign a law, did you?
No.
Did you sign the Social Security Act?
No.
Then you have no standing. Did you sign the Constitution?
Right. No.
That's the general contract. You have no standing. So correcting anything is not going to correct anything that they're doing. Correcting means you have to transfer something from one place to the next, so it's avoided outright. So if I open a company and I say I'll pay my own taxes, and my company pays my company, another company pays my company, I can decide to pay taxes or not, because now I effectively become my own subcontractor, and whoever's obliged to follow the rules, principles, and laws of my company now have to follow through with whether or not the model of my company is consistent with how I'm contracting. If I'm consistently contracting on a note of obligation and no other negotiator is mediating what I'm soliciting and it's agreed upon, then how could someone turn around and say, I'm gonna act as your fiduciary? If I'm acting as my own fiduciary, if I'm acting on my behalf, why would I have someone else negotiate on my behalf? That doesn't make any sense.
Yeah. Well, that's what I was fixing to say. That the company that I'm working for, I told them when they told me that they had 401 and the whole 9 yards, and I told them, I said, I don't, want to partake of that, and they wound up going ahead and enrolling me.
But you signed a contract, didn't you?
For employment, not the benefits that come along.
Well, that's the problem. It's a unilateral contract. Thank you, Marcia Smith. When you contract with them, you're not contracting one side. There is no one side to two-sided teeter-totters. Two teeter-totters have two sides. You sign one, you take the other. You accept one, you accept the other. It's a default. It's almost like if I bought this house, I didn't accept the mortgage. They say, well, you signed it. I said, well, I didn't accept the other terms and conditions with it. Well, it comes with the contract.
Okay, it's in other words, it's a hidden. In other words, it's a hidden part of the contract.
There's nothing hidden. Everything's in front of you. You didn't read the contract. That's majority of the problem. Majority of the problem is people don't read contracts. No one reads an entire mortgage. I read an entire mortgage, and it might annoy them, but when I saw all the flaws, I said, okay, I'm gonna sign here and do these things. And when those things came to fruition, the language was consistent with what I was negotiating for, which was the terms and conditions of my benefit, not theirs. I'm not raising money for an institution that hasn't given me anything in exchange for it. They're giving me nothing. Why would I accept something with nothing attached to it? It makes no sense. Arbitrarial sense. I mean, and me arguing with them is just stupid, because I'm actually telling them that I'm incompetent in what I signed. That's what they're in fact doing. That's what they do to the majority of the people that go to court. So here it is, incorporation. One or more incorporators may organize a corporation under this act. Each incorporator shall be either a corporation, domestic or foreign or natural person of the age of 18 years or more. Unless otherwise provided in this article of the incorporation, any action to be provided in section 2.20, section 1.10.10, and section another subsection to be taken in the incorporators of incorporations may be taken without a meeting if the consent in writing setting forth the action so taken shall be signed by all the incorporators. Now, this is a business corporation under the Business Corporation Act of 1983. This is in the state of Illinois. I'm gonna go ahead and post this for you guys. And what I want you again to realize is that when you're looking at when someone extends a particular type of corporation, or a corporation is offered or pledged to the public, I'm gonna go ahead and I'm gonna pin that real quick. Let's see here. Natural signature with knowledge. Well, Miss O'Neill, it's not necessarily about knowledge. It's about exchanges. If you exchange something with knowledge, even though you lack the knowledge of the contract, it's not their obligation to explain that to you. If you act incompetent by not reading it, then it's assumed that you're competent. So you're either competent or incompetent. Which one are you? You remember teeter-totter. You're either competent or incompetent. You accept one side and the other one's gonna go by default. You may have had knowledge of it, or let's say you didn't have knowledge of it, then by default, you have agreed, and therefore you had knowledge. So it's unfortunate, but that's the way they do things. And this Illinois compiled statute right here basically tells you how a corporation has to do things, how it has to set itself up, how it will be accepted by the format in which it's placed in, and all the subsequent contracts it falls into under the Illinois compiled statutes. So there's no scooting away from, I don't want anything to do with tax codes. I want nothing to do with healthcare or Medicare expenses or obligations. Now this is a corporation saying this to the state, and the state's like, well, all those laws apply to you. It says it right here in the Corporation Act.
Right.
They're telling you what you can and cannot do. So for someone to say, no, I don't want that, is to otherwise say that it's an operation. It's not an operational law but they're obligated to do so. It's a default package. If you buy a corporation, you're buying all the liability. If you open a corporation, you're accepting all the laws. The time you start negotiating, you're accepting all the principles of that negotiation in its entirety, even though you may have missed an entire section of the contract. It's not their fault. So by default, you're either competent or incompetent. These are the teeter-totter ways. And when you're competent, but you're defaulted into incompetency because the negotiation collapsed and you found out you were liable for something, well, who's liable for it? Are they or are you? Unfortunately, the way they said the incorporation has to be set up, it's by default and design that they, in pursuant to the law, are going to say you fall under these laws because statutorily you're an employee. If you're called a statutory employee, you are in fact a taxpayer by default.
Yeah, I understand where you're coming from on that.
And remember, and even though they just codify it and it's not in actual laws, that's true. But when companies enter into contracts and then they solidify those contracts to the government, they're saying we are statutory employees and we're going to employ these employees to negotiate with this corporation. And when these employees come in, they go from employees negotiable to statutory employees in fact. And then we solidify our contracts to the government, and the government takes their portion out. And unless we pay their corporation and their corporation comes up with their bylaws and come up with their contracts and solidify funds in a specific kind of way that takes them out of the statutory employees. Now that's how you transfer actual power. You don't transfer it by saying, I want to change the status. There is no status to a statutory employee. You're either one or you're not.
Right.
So if you're a company, you're not a statutory employee until you begin to employ others. But if you don't employ them, but you contract with them, and there's no contract allowing the United States or the state to acknowledge that the U.S. statutory employees, right now I got a company. I just opened down here in North Carolina, right? First thing I did is start handing out, when I employ people, I hand them grant contracts, which then shows that they're not receiving compensation under these particular acts, laws, and anything that would make them a statutory employee. When they see the contract, they say, oh, you're not receiving compensation. You're not receiving wages. You're not receiving labor obligations. You're not receiving anything that statutorily applies to what a statutory employee is. Nullifying that eliminates the tax. So in other words, until you take the language out, it applies.
Okay.
You know what I'm saying? So unless you read the contract in full, then getting out of it is impossible unless, of course, you say, I'm going to sell my contract. That's when things get really unruly. Then they're like, oh, whoa, wait a minute. We talk? Let me take you to the back office. Let's talk about this situation. No. Right. I want to buy my debt, and I no longer need you to service my debt.
Right.
That's what the local IRS agents call themselves. They call themselves financial providers. They're providing a service. They're acting as substitutes to the IRS agents, and they're subcontracted. They even have them up here as subcontractors, statutory or non-employees. Here it is right here. It says there are categories of statutory non-employees: direct sellers, licensed real estate agents, and certain company setters. Direct sellers and licensed real estate agents are treated as self-employed for all federal tax purposes, including income and employment taxes, if all payments for their services and direct sellers or real estate agents are directly related to sales or other output rather than the number of hours worked. That means that they would treat you like an employee if you worked hours instead of, in other words, for wages, than you would work for 1099 and miscellaneous filing fees that you raise by means of selling whatever you acquire, property, whatever you happen to be selling.
Right.
Because real estate is a very general term. Okay, their services are performed under written contract, providing that they will not be treated as employees for federal tax purposes. Let me go ahead and post this because this is so obvious. It's so in your face. You can't deny it. They literally said it. They literally said it. Can't even deny it. Let me show you here. Let me go ahead and ping it. Here it is right here. Statutorial non-employees. It says there in big bold letters at your third or the second sentence after the definitions. It says company setters who are not employees of a company setting place service Wait, hold on. I'm sorry. That's the second definition of the original analog here. Their services are performed under written contract, providing that they will not be treated as employees for taxable purposes. I'll go ahead and put that as a point of reference here. Now, remember, I said real estate is a very general word, so it can be treated any way you like, depending on how your contract's set up. And I'll put IRS reference in there so everybody could see it. There you go. Go ahead, I'm all ears.
Oh, I'm just listening at the moment. You've actually intrigued me on some of this stuff.
Oh, that's good. Most don't. Yeah. It's how did he find out? Why is he doing it and we're not? And why doesn't anybody else understand it? And that'll piss off the average person, but what are you gonna do? And by the way, were you able to repost this time? I sent it to you. Yeah, I sent it to you. Were you able to do that?
I sent it to a couple people, but I wasn't able to post it to my page.
Okay. What I'll do is make it a note of sorts. Oh, there it is. Here you go. I actually can send it as a link instead. There you go. I'll repost it for you. And everybody that's listening and watching, please repost it when you can. Wait a minute. Is that the first one? Oh, that's the second one. Yeah, that's the first one. I reposted the first one on accident. Oh, that was you that posted. Okay. And I made the mistake of taking this down and well, hold on. I think I already did. Yeah, I think I posted that. Yeah, I did. Yeah, and just skip past your first one on there. So anybody, like I said, anybody that's watching, please repost. Of course, you don't have to, but if you don't, it's not educational. It definitely isn't for you. So, yep, but I appreciate it.
Right.
So yeah. Questions? Go ahead. I'm all ears.
Well, you just got me stumbled there on all that. So basically, when you sign into a contract with a company, you're becoming a
statutory employee.
Yeah, statutory employee, which means you have to abide by all their rules and conditions, and that's in their contract.
Yep, and it has nothing to do with you, even though you're contracting. Thank you, Miss O'Neill. Even though it's subcontracted, it still applies to you.
Okay.
See, because what they're doing is it's like you're paying a sales tax. You're paying sales tax on a company debt that the company says the state is charging them for, but you're paying the sales tax for the commodity or exchange. Yet, for some odd reason, since you're liable for it, then how does it apply to you? It's just like asking a company or a business, how does a sales tax apply to you? It's because you're purchasing something voluntarily from them, and now they can pass the cost on to you.
Oh. That's messed up.
So if that's in their contracts, then how could you? Well, it's not messed up. It's a matter of like, for instance, it's a matter of contracting. It's a matter of negotiating. Right. It's a matter of whether you're going to enter into a contract with them or whether they're going to enter in the contract on behalf of you or on your behalf. That's really up to you. That's really your choice. So the control is in the control factors are in your pocket.
Right. Okay.
Mm-hmm.
Well, you answered a few of my questions tonight that I've been looking for.
Oh yeah, well that's great.
Yeah. You found stuff that I wasn't able to, so.
It's on their website. I mean, you can, it's easier than it seems. It really is. It's just I don't think anybody really reads into it because most are not trying to learn it. Most are trying to use it. That's it. That's what it comes down to. It's not about what you want to learn. It's about what you can use. And because you're not reading language in the same thing you caught yourself into, then you become liable for its creation.
So out of
Right.
ignorance, you get mad at them because they're smart enough to know that you're not going to figure it out. So,
Right.
why blame us for something you're in conjunction of our creation? How could you make us liable for that if you didn't know that it existed? You know?
Right. Well, they do say ignorance of the law is on oneself or something to that nature.
Yeah, ignorance
So,
of
I
the
mean,
law is no excuse. It's no excuse at
right.
all.
Right.
Hmm.
I get that last part mixed up all the time.
It's all right. Yeah, and revenue agents, which are the most important, um, um, is an actual job. A revenue agent is considered a job in which the applicable recipient acts as the collections or the acting as a collections agent on behalf of a third party. So it says here, revenue agent, an accountant who works for the U.S. Internal Revenue Services. That means everybody that defaults into a contract is working for the Internal Revenue Service. They're revenue agents. Let that soak in. An accountant who works for the U.S. Internal Revenue Service is a revenue agent. Let it soak in for a moment. Just think about it. Can't make this up. Go ahead and post it for
No,
you
you
guys.
can't. I mean, if it's there in black and white, then it's in black and white, and you can't deny it. So,
And then it goes on to say, let's see here. A revenue agent's job is to examine and audit the financial records of individuals, businesses, and corporations to make sure that tax liabilities have been met. Typically, revenue agents hold a bachelor's degree or, in some cases, an associate's degree in accounting. It also goes on to breaking down the breakdown on revenue agent. It also goes on to say some revenue agents work exclusively on the records of suspected criminals, including drug dealers and money launderers. Those agents who specialize in this field may be required to provide testimony in a court of law. Senior revenue agents generally examine the most complicated tax returns involving individuals and businesses. Revenue agents can specialize in a variety of divisions. These specialists can have, in many cases, an experience of a variety of titles, such as financial products and transaction examiners, FPTEs, international examiners, IEs, and employee tax specialists, ETSs, and computer audit specialists, which is CAS. Now, these are just acronyms. They just use acronyms to provide you a general blip of what the words and the definition of an agent would be. So, in essence, let's see here. Statutorily, it pretty much would fall into the same line.
right.
That one would be a let's see here. Look up earnings and profits tax regulations of the city Kansas City, Missouri, section blah blah blah, as made and adopted. Okay, that's just a general clause for it. So definition: as rules and regulations following words that have explained. Say okay, basis operations. City. Okay, city means the city of Kansas. Missouri is defined in the city charter. Okay, let's look up. Look up agent here. We're going to go back and look at agent. Okay. Let's see. Let's go up to the definition. Taxpayer conference following assessment. It says a taxpayer who disagrees with the assessment issued by the commissioner may request a conference with the commissioner of revenue by making requests within 30 days of mailing of the assessment. When I go down to agent, it says that the conference will not be granted because the taxpayer provided new information that will be considered by the revenue agent assigned to the case, and to revise assessment will be made by the revenue agent. So they're basically saying the revenue agent is the one that creates the assessment and then determines whether or not the assessment will be reassigned and revised based on the assessed value or the exchange of the value in which they're specifying statutorily requires the consumer to pay. So if they're the revenue agents, yet they're telling you to go raise revenue, by definition of, let's see here, let's go back up here and look at the actual statute.
Do this.
Let me skip all the way to, wow, it took me all the way to the bottom there. Earnings and profits tax regulations, subsection 1.381 to subsection 1.402. Now, the funny thing is, this is a general provision for earning and profit tax regulations. So they're saying, if we're going to earn some money, these statutory requirements have to fall in. And the agents, of course, they're collections agents. They're saying that you have to pay it for whatever penalties that would be allocated to a agency or entity, has to accommodate the agent as if you are the agent raising revenue for the agent himself, and then the agent acts as the fiduciary supplying the demand of the payment. He's kind of the supplement middleman. You know, the state can't step in, so they need a physical representation of the state. All right. Each taxpayer making a return shall, at the time of the filing thereof, pay to the commissioner and the amount of tax shown due thereof. It says the taxpayer must retain a copy of the W-2 for 5 years following the due date of the return. Yada yada yada. Now it's funny. It says to the commissioner. It says in determining the amount due, any prior payment made or tax withheld at source is subtracted from the total tax liability from the taxpayer to receive credit for the withholding of all forms, W-2, Schedule K-1, and other documents, including Kansas City, Missouri withholding, must submit with the tax return. So in order for them to basically balance your account, they say that you have to give your W-2.
Yeah.
So
Yeah,
that's your
that's
your contract.
Yeah, your W-2 is your ledger, basically.
And they're saying that they have to assess the amount in order to withdraw or withhold the amount that they have to credit your account for. So who does that? Banks do that, don't they?
They should.
Well, they do, because they're supposed to. They're supposed to be your withholding agents. So if you're getting paid at a bank and your bank's receiving the imposed amount that would be liable and is credited to your account, the Treasury is basically saying to the agent, hey, collect your due, you get your W-2, and once we receive the W-2, we'll turn around and balance this account at federal as long as your state is good. As long as your state is good, we won't transfer that amount, and then, of course, buy the assessment for you or allow you to put a lien on the taxable amount that's owed to him by placing it on the public record, indemnifying that is a contract outstanding and an obligation has not been paid. You haven't discharged the taxes that you owed, have you? No, I'm talking about federal, not state.
No.
Okay.
I've stopped paying state and federal altogether. I just don't do it.
Are you employed right now?
Yes.
No,
yeah, I haven't been doing
it. When you say employed, what this means is that even though the company isn't taking it out, they're not taking it out for you, right?
Right.
What's going to happen is eventually when they get audited, they're going to find out that you haven't been filing because they're the agents that's supposed to be withholding your money. That's what the contract says.
Right.
They're your withholdings agents. So eventually when they get audited, they're going to come after you. I'm letting you know because I know.
Okay.
So what I would suggest is have your company paid instead of you paid, because then you can transfer the debt to the Constitution. You can transfer it to a statute. You can do any of those things and make it look like a deduction, which is 100% write-off. And then you say that by writing it off, you're no longer raising funds on behalf of the agent that is coming after your revenue. United States, the state, all these agents that are in the middle, that statutory reference I gave you, where the agent is the middleman in collecting taxes on behalf of your state and your city. Secretary of State, governor. I'm looking at some other stuff right now. But everything, of course, if you enjoy a benefit of those regulations, it becomes a default tax, which eventually will definitely catch you by the toe. It's just a matter of time on that note.
Okay.
And I'm not saying you have to pay them. You don't. The thing is that it has to be transferred. The taxes, or let's just say the statute and the obligation of it has to be transferred in order for it to be negotiable. Can't just go in there saying that, hey, I'm not negotiating the terms and conditions of what you say I have to pay when the company itself is paying the tax out of your taxes, and they're not going to be liable for it. Who would do that? Who would find themselves liable for paying for something that they don't want to pay for?
Nobody.
Exactly. So if you're a company and your employee decided he wasn't going to be taxed, and then eventually they came after your money because you're being taxed, would you allow that to happen?
No.
Okay, then. So, you got to get going, my friend. You got to get going.
Okay.
Because they definitely are not, your company is not going to take a hit because, you're not going to act as a liability party.
Right.
They know that. I know that. You know that, right?
Yep. Well, I know that now.
Well, yeah, it's a warning shot. I'm giving you a warning shot before it does happen. Yeah.
Okay. So how would you change that
Say what?
situation? How would you change that situation? Basically go in and change your W-4s?
No. Why would you do you don't have to change anything. That's what I continue to say. Changing something doesn't necessarily change the status of your payments or your debt. What you need to change is your affiliation to the company. So you're no longer a collections agent. You're in fact a company receiving compensation, and then you're writing it all off because you're contracting it in a different format that doesn't apply to a statutory employee. So to eliminate statutory employee, you have to get rid of the word statutory employee off of you by subcontracting yourself to something else so that it doesn't become applicably. A lot of people go, oh, I'm going to use a nonprofit. I'm going to use this. I'm going to use it. Just use the most simple, basic financial application apparatus, which is a company. You can use the LLC, so probably it could be any number of things, but you make up your own rules, you make up your own contract, you make up your own financial strategy, and ultimately, whatever your contracts say apply to you and you only and no one else. Now, all the Corporation Act, the Business Corporations Act, and things of that nature in the states, those ultimately have to be, your main focus, which is to eliminate things that would make you a statutory employee. That's what your main focus should be. Take yourself out of the statutory employee. You no longer become an applicant for debt.
Okay.
But the time you you allow them to stir the churning waters of, oh, you're liable, then you know what time it is. Yes, I'm still live. Yes, I'm still live, my friend. Excuse me. So there are statutory employees and there are non-statutory employees.
Okay. I got to look into that one.
Most definitely.
All right.
Everybody should too, because if you don't, well, you know what time it is. You know what's going to happen. You step off in there talking about, I'm not a statutory employee, and they're contracting you as a statutory employee. That's the company's status. That's not your status. But you're trying to correct them on their status that they created for you.
Right.
You don't want to do that. You just want to go at it.
Basically, you have to terminate that statutory employment and recontract with them under your contract.
There you go. There you go.
Gotcha.
So in essence, it's all about the formality of contracting.
Okay. All right.
I mean, if you're not changing that, then you're basically telling them that they can act in your capacity to do as you would otherwise be non-negotiable to. Like, I don't want to be a statutory employee. If I am, then I don't want to imply that I'm a statutory employee because that makes me liable for things I don't want to pay for. I want to pay for things that are not mine. That these IRS codes, these IRC codes, these statutory codes, all this stuff, it doesn't apply to me. But they can agree with you. Yeah, you're a good guy. We totally understand, but that's irrelevant.
Right.
Relevancy is whether or not you got a contract. That's it.
Right.
You know,
Okay.
and until that happens, I mean, what? How else can I put it? You know, you're in a trap, so to speak.
Okay. So terminate the employment and re-offer contract with them.
Well, not re-offer because you're giving them an offer they can't refuse. A company can receive compensation and not be liable, as long as its contracts are set up properly.
Okay.
So, I
In
mean, you
order.
know, your contract is all about um, your contract is all about the way you want it to be applied to you and your circumstances and your situation. And it could be, I don't want to pay taxes. I don't want to transfer debt. I don't want to contract with you in this sort of way. I want this language to change because my company's policies fit this particular criteria, blah, blah, blah. You make it up as you go. It's about how you decide how your negotiation goes down. It has nothing to do with the company at all. They have no control over that. Hold on a minute. Let's see here. What do we got?
Chris is right.
I'd say what?
Chris is right. This is by having a driver's license, you are a statutory employee of the state and not
And
receiving any
not receiving any
benefit.
benefits. Correct. Correct. That is correct. Matter of fact, that is the sole purpose. Um, Hold on a minute. I'm sorry. So the sole purpose of a driver's license is to determine whether or not you're making revenue on the street, whether you're making revenue on the sidewalk, whether you're making revenue on the if you're negotiating in some way, shape, form, or fashion for commercial purposes. To
Right.
raise revenue on behalf of agency because the agency gave you a commercial contract to drive your vehicle. So,
Right.
I mean, it's vice versa. You take the liability by signing an obligation, and it defers one against the other, and they become one and the same. So it's impossible to evade unless your contracts are
Right.
proper, unless you
Right.
have specific language that either are struck out or you specifically statutorily require that those particular words do not apply to you specifically. Like I used to work for a company long ago, and what I did was is they said that certain things would happen in the contract if I didn't agree to certain things based on what the company may do. So I said, okay, would it hurt me working for the company? He said, well, technically, yeah. I said, okay, then I'll just strike these words out. And the boss was like, okay. And why did he say that? Because he knew that at the end of the day, I wouldn't agree to the company hurting me because it saw me as a valuable exchange, but not as an actual commodity, as someone it needs to
Right.
keep because it would become liable to me and not me liable to it. So
Right.
he kind of see where I was going with that. It's hidden in the Arkansas code as political subdivisions. There's nothing hidden. I wish people would stop saying it. There's nothing hidden in the laws. Laws are, that's why they call it codes, because it's there. They codified it so the public knows what they're doing. You're not reading them. They're not hidden anywhere. They're in broad daylight. You just decided not to pick up a book. I know it's
Right.
dumbfounded. You're looking right now, Boris. You're like, well, damn, he's right about that because I didn't read my contract. This is what
Right.
happens when you don't read your contract. Don't look stupid. Oh man, I didn't have anything to do with this. Please help me, mommy. Yeah, you can't look for nobody now. Now you screwed up. You didn't read it. This is what happens. Send results.
Right.
You
Right.
know what I mean? So until people read what's contractually available to, I looked up a website. Like, come on, man. I went and looked up a website for codes created by the IRS, and I found it in less than 3 minutes. You're telling me you couldn't find that in a lifetime? Is because you chose not to look for it. And not because you're not looking for it the way you want to. You're looking for it the way you think it should be looked up. Like, this is what they said. No, this is not what they said. It's what they wrote. So unless you know what they wrote or you understand why they wrote it, I mean, why would
Right.
they write a statutory employment in a hidden code, raising revenue, and never telling you what's in the contract if you read the contract?
True. True.
Hmm?
You're right.
The only thing that applies is what you know. So if you don't know, it's because you didn't read it or you just chose not to acknowledge it. And Chris Ward, please repost this since you got so many inquiries over there. But don't give me the flat tax of sharing to your community. It's very important. But yeah, I'm gonna let everybody get a rest in. I think I gave you just enough to chew on tonight. And I'm sure everybody will start reposting and putting up silly memes or something out of that nature to say what kind of empire they've just now created simply because they understand and reading the contract is more valuable than acting like there wasn't one that existed in the first place. And of course, if there was one and there is one, you know how to use it, so.
Right. Okay. Yeah, definitely. I'll go in and look at these posts that you posted on here and dig through them. That'll give me something to do over the next couple of days.
Oh yeah, and then we can hit the live again and enjoy a little battle of wits. I'm sure you'll catch up. Everybody's looking for a way to get to the next level. I'm trying to get us to the next level.
Right.
That's going to take some cooperation. A lot of thought, and some foresight.
Yep.
Right, so.
That's what it's about. Everybody educating everybody.
Mm-hmm. Yep.
So, well, I appreciate your time, and we'll hook back up for another live feed.
Sure thing, and I appreciate you coming through.
All right.
All right.
Well,
Oh yeah, most definitely. I definitely got to get some rest. Tired.
Right.
Mm-hmm.
All right. Well, you have a good night, and we'll speak with you later.
You got it, champ.
All right.
All right.
Later.
Hey, man. All right. That was Mr. Boris. That was fun. I think somebody said something else. I didn't see it. Do not know the DL or driver's license was a contract until recently, but don't worry. I'm correcting a mistake in my error. Well, I'm not sure exactly how that'll work, but error is not necessarily that they don't have a contract or that you don't have a contract or you never agreed to it. It's about how you solicited and how it's going to be revenued in the future. So anyway, this is Politics and Money. It's Professor Phil. I'm in the building. Zet Tepe, of course, as well. ZetTepe.com, ZepTepi.LLC.com, and Politics and Money, www.politicsandandmoneyinc.com. It was nice talking to you guys, and I hope you enjoyed yourself. I hope you enjoyed the video. Dropped a lot of information like I always do, and just good at it. I'm just good at it, okay? Nothing I can do about it, all right? I'll let y'all in a minute, fun fans. I'll let y'all in a minute. Peace.